Good morning. Thank you for the party's patience. Court is now in session. Calling case number 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Grunander, Ryan McBride, Lauren Hunt, David Sturgill, Chris Ballard. For the state, County Attorney Jeff Gray also present.
Good morning.
Good morning, Your Honor. Kathy Nestor, Richard Novak, Michael Burt, and Stacy Visser here for Mr. Robinson, who's seated at council table.
Good morning.
Good morning.
Good morning, Mr. Robinson. And for the record, the court also recognizes the presence of Ms. Erica Kirk. Good morning, Ms. Kirk. All right, as you've probably come to expect, I do need to read the following as it relates to today's preliminary hearing. The court is mindful of the safety and well-being of all parties, counsel, witnesses, court staff, and members of the public who may be present. The court is also mindful of its duty to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. To serve those important interests, the court reminds all persons who will be in attendance that portable electronic devices will not be permitted in the courtroom or on the fourth floor. And this prohibition does not apply to legal counsel and support staff for the defense or the state or the media in this manner, or the equipment permitted under any electronic controlling electronic media coverage order, and includes the counsel for victim representative Ms. Kirk. I do ask the parties, the attorneys, if you will join me in turning off your ringer to ensure that we do not have any interruptions. So I am turning off my ringer, and I invite you to do the same. Every person who is in attendance today and every day will be afforded the dignity and respect due to them, and pursuant to the standing decorum order by the court, all spectators shall be quiet, civil, and orderly. Spectators shall not engage in any distracting, disruptive, provocative, disrespectful, uncivil, or threatening behavior of any kind. Spectators shall not make any audible comments of any kind, shall not shake or nod their heads, shall not otherwise make any gestures during the hearing. Spectators shall not wear or display pins, buttons, signs, clothing, or photographs expressing support for or against any person related to this case or to the status of this case as a capital offense. All right. As we begin this morning, I wish to, I've taken a lot of time to think about the comments made by the parties yesterday, and there were additional briefings and a motion filed last night, and the court took the necessary time to readdress it and look at it and be prepared for this morning's proceedings. While I recognize especially how precious our time is, I also recognize that I need to be prepared for everything that's before me. And I took the time this morning to review what was filed since we adjourned yesterday until we came back on record. One of the motions filed last night was filed by Ms. Erica Kirk's attorney, and I wish to address that. And I realize that the parties may not have had a chance for defense or prosecution had a chance to respond to that. And before I address that, I wish to turn the time to you if you need the benefit of the record as it relates to what was filed by the attorney for victim representative Erica Kirk to the state.
Good morning, Your Honor. Christopher Ballard on behalf of the state. We have reviewed that filing, and we believe that it fully accords with our position in our filing this morning that publishing exhibits to the courtroom is entirely appropriate and indeed honors the victim representative's right to be present in at this hearing.
Thank you, Mr. Ballard. To defense, Mr. Novak.
Thank you, Your Honor. I read the pleading. I believe that every order that this court has made to date complies with and respects the victim's rights under the Utah Constitution. I think that the rulings that the court has made the last few days do so, and I don't believe that the issues that are presently before the court going forward with the hearing with respect to exhibits in what I'll just call the 16 series interfere with any of the enumerated rights set forth in the Utah Constitution concerning the rights of a victim representative in any criminal proceeding. So that's our position. And I want to also be very mindful of timing issues because we spent a lot of time arguing without the court having the benefit of briefing yesterday. But we have witnesses we have to get to, including a defense witness who is not available after tonight. So I could, of course, as Your Honor knows, say much more, but the court has all the briefing, and I think we should move forward.
Thank you. And as it relates to transparency and publication, does the news media wish to be heard on this issue?
Only briefly, Your Honor. I've also reviewed the submission from yesterday. The court has always set this three-step process, and I think taking each of those stages, admissibility, publication to the courtroom, and coverage by the in-court cameras are three separate inquiries. Of course, the media believes, the media will be the party who stands here at this lectern and says, we believe we should see as much as possible. We're maximalist in that way, while recognizing the importance of protecting all the rights, including fair trial rights. But the idea of publishing something, of keeping something off of the cameras at the rear of the courtroom, but publishing it to those who are present here also is a meaningful step towards transparency. And to the extent that the court is not comfortable with placing something on the video feed, the media does believe that allowing the media representatives who are here and the members of the public who are here to view that, even if those watching on the live stream cannot, is a meaningful victory for transparency, and we, of course, support that.
Thank you. All right.
Your Honor, the state would like to be heard on the briefing, briefly.
For?
The briefing that was submitted last night.
All right, so I want to address the motion filed by the attorney for the victim representative, and then we'll transition to that. I'm just trying to do it incrementally so we can get it all addressed. So in regards to that, and I appreciate the position of the parties, it is important for me to hear all sides. Article 1, Section 28 of the Utah Constitution recognizes important rights afforded to victims and victims' representatives, including the right to be treated with fairness, respect, and dignity, and the right to be present and heard at critical stages of the proceedings. The court acknowledges the concerns raised in the motion regarding transparency and the ability to meaningfully observe the evidence presented during this hearing. At the same time, the court has an independent obligation to manage these proceedings in a manner that safeguards the rights of all parties. That includes honoring the rights of victims and victims' representatives while preserving the defendant's constitutional rights, including the right to a fair and impartial process. The court has considered the request that exhibits be displayed in real time to the courtroom. After careful consideration, the court determines that not all exhibits will be visually displayed to the gallery, and notes that it will use a tiered method as described. First, whether it will be admitted to the court for consideration as it relates to probable cause. Second, whether it will be displayed only to the gallery. And third, if it will be published through the camera to the public at large. This ruling is not intended to diminish the significance of the victim's representative rights or concerns. Rather, it reflects the court's responsibility to regulate the presentation of evidence in a manner consistent with the integrity of the proceedings and the fair trial rights implicated in this manner. The manner in which evidence is displayed remains in the court's discretion. That discretion must be exercised in a manner that is appropriate and appropriately balances Mr. Robinson's constitutional rights, Ms. Kirk's rights as a victim representative, and the court's obligation to conduct the proceedings that are fair, orderly, and appropriately transparent. Transparency is an important principle, but it must be maintained in a manner consistent with the constitutional rights and protections afforded to all parties. The court does not make a blanket ruling as it relates to any exhibit, and as previously stated, each exhibit will be afforded its own due in weighing whether it shall be published to the courtroom or beyond or not. And that concludes the court's ruling on that motion. All right, counsel, the last matter, as it relates to the briefing, I'll hear that, and there is a slight edit to, and I'm not sure when the state wishes to publish State's Exhibit 16. So turning to the state, do you wish to be heard about the motions filed last night prior to the publication of Exhibit 16? Again, it's your choice on how you move forward. I just want to see which order you want to go.
We do want to be heard on the briefing from last night, and specifically about Exhibit 16. I'm understanding Your Honor has an additional edit to that. Is that correct? I do,
and there might be value in hearing that, so that may or may not change your positions. So let me just put that on the record,
okay,
and then I'll hear from you. I just want to make sure you're able to be afforded everything. So as it relates to the edits, last night, I believe it was between 6 minutes and 57 seconds and 20 minutes and 29 seconds, which is not to be played, and then 32 minutes and 55 seconds to 35 minutes and 47 seconds, which is not to be played. And I believe that what I received reflects that. And is that the understanding of the parties?
Yes.
All right, the state has said yes to the defense. I'm not saying if you agree with it, I'm just saying, does it reflect the timestamps?
May I have a moment?
Absolutely.
Judge, I think, Your Honor, and then let's just see what the court is referring to.
Well, I'm asking, did you receive a copy of the edited video?
Okay, so I'll answer that question directly. The state sent us a copy of the edited video. The redactions of the audio were exactly as the court ordered, but we noticed that the video, which followed, ended up being inconsistent with the redactions of the audio. So I brought that to the state's attention last night. I believe that they ultimately forwarded to the court what I'll call version 2 of the redactions, which redacts the video that would have made the audio redactions sort of superfluous or ineffective. So that's sort of where we are. But we may be not communicating with each other about the same issue. I'm not sure.
Well, okay, I just want to make sure that in regards to what was to be cut out comports with those timestamps I just gave.
It does. Plus, the parties believe that additional video needed to be cut out to match the court's intentions with respect to the audio.
Right, and this is where I'm going to next. Mr. Ballard?
Yes, Your Honor. I think we're on the same page. We did, in conjunction with discussions with the defense, first of all, we prepared the redacted video as Your Honor ordered. Then after discussing with the defense, we prepared a second version that still maintained the audio redactions as the court ordered, but we took out the video portions that the defense brought to our attention.
All right, and I didn't see that, but here, and this is the court's own independent finding after spending significant time last night reviewing it. So I'm requesting a video-only redaction between 20 minutes and 29 seconds and 25 minutes and 23 seconds. And so what I looked at was what was on screen. So any video showing anything other than Mr. McBride and Lance Twiggs was to be redacted, with the exception of the screenshots of the images pulled from the surveillance video and the FBI bulletin, which I believe was also briefly displayed.
I think we're all on the same page, based on what the court just said.
Your Honor, I think we have just a 1 second difference. Our timestamp is 25:22 of the additional edited version, but I think it still omits the video portion that we're discussing.
All right, well, it's a good day when we are literally on the same page. I'm glad that within 1 second we are all in agreement about this. So that the court, and it sounds like you're one step ahead of the court. I was going to say that if you had it, you simply turn off the monitor for that section. But if you've already made that change, then all the better. There are 2 additional changes as well. And this is very short, and so I'll leave it to the state if you wish to just in real time pause and fast forward or wish to redact it. I'll leave it to you. So the additional requested audio and visual redaction, so this is not to be played whatsoever, is 27 minutes 18 seconds to 27 minutes and 25 seconds. And the second is 28 minutes and 11 seconds to 28 minutes and 18 seconds.
Your Honor, just to make sure that we've got that correct, the additional redactions would be 27 minutes and 18 seconds to 27 minutes and 25 seconds.
Correct for the first one.
And then 28 minutes and 11 seconds to 28 minutes and 18 seconds.
Yes.
And Your Honor, while we're talking about additional redactions, let me approach. When Your Honor made his ruling yesterday afternoon, it wasn't entirely clear the basis for these redactions that the court proposed. The state's understanding was that those additional redactions were based on the potential that the video 1102 would be showing duplicative evidence and would be displaying evidence that would be duplicative of future exhibits. And then also potentially a concern about admissions by the defendant. Portions that the court has ordered to be redacted do not have any of those concerns as far as the state's view of that evidence. And I would like to be able to point the court to those. We've got 2 brief portions that we believe don't implicate those concerns and should not be redacted.
All right.
Does Your Honor have the transcript?
I do.
In front of you? Okay. First of all, at the very, very bottom of page 10, beginning with the words, "was he?" and then over to page 11, down to timestamp 1646. That portion is not cumulative of additional exhibits, and it contains nothing that could be classified as an admission by the defendant. That's the first portion.
So going back to page 10, I don't see "was he" at the bottom. Where are you? How many lines from the bottom up are you referring to? You may. Oh, I see, right here. Okay, now I see what you're saying. I missed that. I was looking at the beginning of the line, but I see your point. Okay. So from "was he" on page 10 until
16, the timestamp 1646 on page 11.
okay.
That's the first portion. And then the second portion that we would ask not be redacted is a small portion of page 19. And it begins, let's see. It would be the 5th paragraph down, Mr. McBride stating "okay," and then ending at timestamp 3340. Again, that's not cumulative of any anticipated exhibit, and nor does it refer to any admission by the defendant.
Thank you. Yes, you may.
Thank you, Your Honor. With respect to the first of the two portions that Mr. Ballard referenced, I want to be totally transparent with the court, of course, that was not a section that we asked the government to agree to redact. That is a section that the court independently determined was appropriate for redaction under the various principles that the court has enunciated. So I just want to be transparent about that.
Thank you.
The second portion that Mr. Ballard addressed, which is on page 19, we did suggest, and it is in our highlighted, redacted transcript,
See that?
and the court agreed with us. This is not relevant. This is not admissible under 403. I don't understand how this questioning by Mr. McBride and the answers to these questions by Mr. Twiggs, and now I'm going to quote the Utah Rule of Evidence, has any tendency and reason to make a fact of consequence more or less true. That's the relevance question. So I understand that the court has said, I can make determinations of which portions of this transcript to rely upon, but from my perspective, what the state is asking the court to do is to broadcast a portion of the transcript which we are saying is not relevant, and to the extent it has any relevance, is significantly outweighed by undue prejudice.
All right.
I am not Mr. Twiggs' representative, but I think as a witness who has counsel, there might be something that Mr. Twiggs' counsel would want to say about this as well. I don't know what it would be, but my firmly held belief is it would be consistent with what I'm saying, which is that it is neither relevant nor probative of anything of significance, especially in compared to the undue prejudice. Thank you, Your Honor.
Thank you, Mr. Novak. Mr. Ballard.
Thank you, Your Honors. Mr. Novak recognized Mr. Twiggs was represented during this statement. His counsel knew that this was being prepared to be produced in court, and his counsel made no objections to this part of the interview. And this is critically relevant. It provides important foundational information about Mr. Twiggs and identifying information about him, and then also it's very relevant to the enhancement that we have charged.
All right. Thank you. Anything further before the court rules on these two requests? All right. In reviewing the first section, again, citing to page 10, and I know it is, to anyone listening, this may not make sense when I'm saying page 10, but it's roughly just a few seconds after 1539 on the video, starting with "was he," and ending at 1646 with the last word "asking." After hearing and considering what has been argued, the court agrees that this, in applying a balancing test and as it relates to transparency, to ensure the court is taking a very narrow approach in what is or is not published to the public, that this is permissible. It doesn't run afoul of the issues that the court addressed previously, that the court is trying to avoid by publishing portions. And in addition to that, independently of the court's decision-making, it appears that the parties also agree as it relates to the first requested edit to unredact or to allow in. So I am ruling that that may be played and published through all mediums in the courtroom and via video. Turning to the second section, this is page 19. It is roughly right after 3327, going to just before 3340.
Sorry, Your Honor, just to clarify, what we asked was just before 3307.
3307?
Correct, yeah. Yes. Right after 3255, where Mr. McBride states, okay.
I see, thank you. Let me just take a quick second to review this. In relation to that request from right after 3255, starting with okay, is that the spot you're talking about, Mr. Ballard?
Yes, Your Honor.
All right. And specifically to 3327, the court stands by its original ruling. That is not, there are several reasons why the court the court's ruling isn't whether it's relevant or not. It's whether it should be published or not. And again, as previously stated, the entirety of Exhibit 16, the court is receiving without any redactions or edits. The court is considering it as it weighs probable cause. However, for publication, the court finds that the requested section from roughly after 3255, starting with okay, ending at 3327 is, the court finds that there are interests served by not publishing this to the courtroom or to be broadcast. I note and I recognize Mr. Novak's statement as it relates to what Mr. Twiggs' counsel may or may not assert, but the court finds independently that this this portion shall not be transmitted into the courtroom because of certain statements made in there that do not serve the interests of justice for publication. However, the court finds from 3327, starting at OK, until just before 3340, I'm sorry, up to 3340 may be published. Did that notation make sense?
Did to the state, Your Honor.
All right, to defense.
Understood.
And so this is the appropriate balancing of being transparent while at the same time maintaining the constitutional rights or balancing the constitutional rights of all parties and what is appropriate for publication. And this may be published not only to the gallery but to the media as well, that goes beyond the gallery itself. All right. Anything further on State's Exhibit 16?
Not from the state, Your Honor. Thank you.
All right. And I note defense is nodding their head as well and not indicating any more is needed to be discussed at this point. All right. I think we've put State's Exhibit 16, we've addressed it. Turning to the state.
Thank you, Your Honor. We would just like to briefly emphasize a few points in the briefing that we filed early this morning. Last night, the defense raised the issue of publishing admissions by the defendant or confessions. They cited to one sentence from the United States Supreme Court opinion in Estes versus Texas that relies on the Rideau versus Louisiana case. And that one sentence in Estes has no precedential value on the issue that's before the court today. Estes cited to the dissenting opinion in Rideau, which is very curious because that dissenting opinion, Rideau was a change of venue case, and what the dissenting opinion held is that the court properly refused to change venue in that case, even though the defendant's confession had been televised multiple times. So it's puzzling that that's what the Estes court would rely on as supposedly constructing some kind of rule about publishing a defendant's admissions. In addition to that, Estes has no analysis of that point from Rideau. Again, it's just one sentence, and Estes itself was a case about televising a trial. It wasn't about pretrial publicity of a defendant's admission or confession. And as we noted in the brief, subsequently, the Supreme Court has limited, although it hasn't expressly overruled Estes, it's limited that case to its very narrow facts. So it's difficult to see what precedential value that one sentence from Rideau could have on this issue before the court. Even if it could have some applicability here, the circumstances in Rideau are starkly different from the circumstances here, the statements, the types of statements from defendant that we're talking about. In Rideau, what the police did was orchestrated a recording of an uncounseled, unmirandized police interrogation. The police recorded that interrogation. It was leading questions. They recorded the defendant answering those leading questions. And then they immediately, it was the police that immediately released that recording to the press, who then publicized and televised that. The defendant confessing to police, answering the police's questions. That's not the types of statements that we're dealing with in this case. What we're dealing with are statements that defendant voluntarily made to close friends and associates of him and his roommate. Sorry, just one other point about Rideau and that dissenting opinion. It's interesting that in that dissenting opinion, that judge that the court relied on in Estes continued on in his opinion and said it's an impossible standard to require that a trial court be a laboratory that's completely sterilized and free from any external factors. So again, it's hard to see how Rideau has any precedential value, and even if it did, the circumstances are completely different than from the types of statements that we're dealing with here. The state has also cited to several other courts that have easily distinguished Rideau and have made it clear that there is no blanket ban on publishing, especially just in court, a defendant's voluntary admissions. I think the most interesting case is the Sixth Circuit case, because there it dealt with essentially the issue that we're dealing with here, which is publication of a defendant's statements during a preliminary hearing. And that case is especially important, the DeLeslie case, because there that confession was ultimately held to be inadmissible. So an inadmissible confession was played to the public and interested media members so that in a way that it had, as if it had been played in a preliminary hearing. And even though that confession was subsequently publicized and ultimately held to be inadmissible at trial, the court did not hold that that was a violation of the defendant's fundamental rights there, that the court could deal with that through voir dire. It was not inherently prejudicial. And then the state has also cited to the Ohio case of Mamon, and then also the Alabama case, Burgess versus State, where those courts reached essentially the same holdings, easily distinguishing the Rideau sentence from Estes and making it clear that there's no blanket ban on publishing a defendant's admissions, and also that Rideau is easily distinguishable. And because the court can deal with those pretrial publicity issues in the way that we've discussed several times already through the tools that the court has available in selecting the jury. I think it's also important to point out that transparency is critical in this case. This court's noted repeatedly the extensive media coverage. That's why we're having to take this additional time in these hearings to be able to discuss these issues. And transparency is critical to the state's right and the people's right to a fair trial. Where there's a vacuum in the evidence, it just fuels speculation. And then finally, as has already been argued, it's critical to the victim's right to be able to attend the hearing. That's a hollow promise if the victim representative is only able to be here physically, but then is shielded from some of the evidence. Does the court have any questions?
No, not
Thank you.
at this time. Mr. Novak.
Thank you, Your Honor. The parallel between Mr. Robinson's case and the Rideau case is this. Mr. Rideau's confession was televised by an act of the state. it wasn't a confession broadcast through a courtroom. It was a confession made to law enforcement and then broadcast by action of the state. And that's what gives rise to the constitutional problem, which is its state action, which violated Mr. Rideau's right to a fair trial. This court has granted the media's request to electronically publish this entire proceeding. That's state action. And the state has supported the media's request over Mr. Robinson's objection. So that is also state action. So that's the parallel. If there were no cameras in this courtroom, we would not have a problem. And in fact, Ms. Kirk's attorney's briefing seeks a remedy which has nothing to do with the cameras in the courtroom. What Ms. Kirk's counsel seeks is the opportunity for people in the courtroom to see the evidence. So the state is going even further than Ms. Kirk's counsel. The state wants to publish what it calls confessions in the same way, essentially, that the state published Mr. Rideau's confession. Now, the only other thing I want to talk about is that Mr. Ballard's correct that the blanket rule that there is unrebuttable prejudice that's stated in Rideau. We could talk about why dissenting judges say, oh my God, the court has established a rule and I don't like it. That's what's going on there. But it was in the Skilling case, a Supreme Court decision in 2010, where the court said, yes, we really are going to let judges decide whether potential juror exposure to pretrial publicity makes them makes them unable to serve. But there is an extreme case. That's not my language. That's the Supreme Court's language in Skilling. There are extreme cases of pretrial publicity where prejudice is going to be presumed. And so that's obviously about what has to be proven in terms of the prejudice. But when it's an extreme case, what the Supreme Court is saying in Skilling is there's a presumption. And I believe that this court has already made findings over the last 9 months that this is an extreme case with respect to the quantum of pretrial publicity, the way in which it's being monitored by the public, the speed with which